Yes, alternative dispute resolution, since it's got a name alternative, is an alternative to resolving disputes through litigation. Litigation, as everybody knows, is the court system that we have in the United States, which is for business disputes one of the most common ways of resolving disputes. Well, there are a lot of negatives to litigation. Those would include it takes a long time, it costs a lot of money, the resolution of the dispute is left to a judge or a jury, so it's rather unpredictable. So years ago, business people in particular, decided that it might be a good idea to come up with alternatives to that. And the three main alternative methods of dispute resolution that we talk about are negotiation, mediation, and arbitration. Those are the three main alternative dispute resolution methods that businesses use. The difference between negotiation, mediation, and arbitration are important to understand. Negotiation is the process by which, if you and I have a dispute, we talk it out, we discuss it, we work on it together without the assistance of outside people other than perhaps our attorneys. But we basically work together to talk through our dispute and come up with some sort of a resolution. That's negotiation. Mediation, on the other hand, is where we involve an outside party, and that outside party is called a mediator. And the mediator is the person we hire to help us negotiate, if you will. They are an independent, neutral third party who doesn't have any stake in our dispute, and we hire them to use the skills they have in negotiation and facilitation and maybe even evaluation to help you and I resolve our dispute with their help. Still, we're the ones making the decision and coming up with the resolution, but with the help of this neutral third party. Finally, arbitration is totally different than those other two. This is where we hire essentially a neutral third party to decide our dispute for us. We're bringing in someone who probably has some expertise in the nature of our dispute, and we agree to submit the dispute to this person, and we'll even have a brief informal trial before this person, and they will make a decision that we have agreed will be legally binding on us. Well, I practiced law for 25 years before I came to Missouri State University in 2005, and I did a lot of civil trial work. I handled a lot of cases in jury trials and in trials before judges, and that was the way that I was trained, and that's what we knew to do when I started practicing in 1980. And I think the civil trial system in America is a good system, and it's a necessary system, and there are a lot of cases that really need to be tried to a judge or a jury. But over the course of all that, I saw that there were a lot of downsides to the litigation system in America, and those I've mentioned already. It takes a long time. You might file your case today, and it might be, depending on what state you live in, 5 or 6 years before your case is resolved. Also, it's very expensive. You have, in addition to the delay, you have attorney's fees, and you have perhaps expenses for expert witnesses and all of that, and it's very expensive. The third big disadvantage I saw was that the parties do lose control over the resolution. They're turning it over to a jury or a judge to decide, and that oftentimes is not what anybody really wants. And lastly, it's very unpredictable. What's going to happen depends on who the 12 people on the jury are or who the judge is. So it's not something you really have a lot of control over, or something that's very easy to predict. And lastly, I figured out after all those years of litigation that even if you theoretically win the case, you've really lost a lot also. You've lost a lot of time, a lot of money. Probably if it was a business case, the people you were litigating with no longer do business with you. You've lost that relationship. And so it was very destructive, even if you won the case, not to mention how destructive it could be if you lost the case. So all of that led me to the conclusion that there must be some better way to resolve disputes, and there is, at least I think there is, through negotiation, mediation, and to a lesser extent arbitration. So I guess the destructive nature of the litigation process is what got me interested in these alternative methods. What I do in the class, the name of the class is Negotiation, Mediation, and Arbitration in Business. I help future business executives. I teach them how to have more productive and more peaceful lives in business. And I do that by teaching them ways of resolving the inevitable business disputes they're going to run into in the course of their career using these alternative methods as opposed to litigation, which I think by definition makes things more peaceful and makes them more productive in their business careers. And so I took what I knew about these alternative methods from my law practice, and I turned it into a course designed for people who were not going to be lawyers or mediators or arbitrators, but who were going to be business people involved in disputes, and they all will be. And I decided that I would use some of the resources that I know business people use in the area of dispute resolution, one of the most important ones being the book Getting to Yes, written by two guys, one named Urey and one named Fisher. And we kind of use their format of dispute resolution, which involves focusing on disputing parties' interests as opposed to their positions, interests being why they want what they want and positions being what they want. So we use that general format, and we use a method of instruction whereby the students learn not only the theory of these different methods, but they also learn the practice of them through role play exercises that we use, where two students or a group of students are assigned to play different parts in a made-up dispute, and they actually negotiate as if they were these people, were these business people in these disputes, and so they learn, practically speaking, how to do them. There's lots of business disputes. Almost every business at one time or another is going to be involved in some sort of an employee discrimination dispute. They didn't hire somebody, and the person they didn't hire claims they didn't get hired because of one of the illegal reasons there are in the law. So employment disputes are very common. In addition to that, many people in business manufacture products that end up getting involved in accidents, and people who are hurt claim the product is defective, so you get product liability cases. Then in other situations in business, another very common type of dispute is a breach of contract case, where someone you're doing business with claims you violated the provisions of some contract you had with them. So those are a lot of different types of disputes with third parties. But in addition, you can have disputes inside the company between partners in a business, or between bosses and employees, or between two employees. And I think sometimes these alternative methods for those internal disputes are even more important, because you do have relationships with these people and you probably do want them to continue. And these alternative methods hopefully let you do that. Yes.
Okay.
One of the things that is a little bit unique about the class is that in recent semesters we've been able to figure out a way to offer the class online. And I've already told you that the way the class is structured involves primarily students negotiating one with the other and practice these theories using role play exercises. Well, we've come up with a way, and we're always revising it, but we've come up with a way where we can have students make appointments to negotiate with each other. Online students, we don't have a class, it's all online. Online students can negotiate with each other on these role plays using recording technologies that allow them from their own homes with their own computers to contact another student, do the negotiation, record it, and upload it to our Blackboard site, where the rest of us can look at it and critique it, just as we would if we were all sitting in the classroom. And that's a very important part of the class, and without that technology we wouldn't be able to offer this class in the online environment, but we've been able to do that recently, and most of the students think it's pretty successful.